CRO of ASIFI. It's a pleasure to be here with you today. Welcome to our webinar on the regulation of virtual assets in Brazil. Our goal today is to clarify the key aspects of the regulatory framework with insights from the expert at BBL law firm, who are valued partners of ASIFI. To begin our program, I would like to invite the BBL team to briefly introduce themselves. Feel free, guys.
Good morning, everyone. My name is Eduardo Bruzzi. I'm a partner at BBL Advogados and responsible for our regulatory area, specialized in banking payments and crypto regulation. Here with me, we have Cirano, Pedro, and Ana Clara, who are going to present themselves for you.
Hello, everyone. Pleasure to be here. My name is Pedro and I'm the tax partner at BBL Advogados.
Hello,
Hi
everyone.
My name is, I'm sorry, Cirano.
You can go.
Okay, thank you. So, hi everyone, how are you? My name is Dana and I'm a senior attorney here in the BBL's corporate team.
Good morning, good evening, nice to meet you. My name is Ciano Cerqueira. I am an associated lawyer in the payments, banking, fintech, and crypto team at BBL. I work with Eduardo Bruzzi.
Perfect. Well, let's not waste more time with presentations and dive directly to our main topic here, that is our recent Brazilian regulatory framework concerning crypto activities, crypto market, and crypto companies who wish to operate in Brazil. As you well probably already know, until recently, Brazil was an unregulated market for crypto companies. So we didn't have a specific regulation and a specific regulator with oversight on this market. But it is an important market with important investments, with several companies, several users of those companies, and it began to attract attention from Brazilian government, and now we have a regulatory framework, and we are at the moment to understand that framework and understand what the companies must do to adapt to this new scenario. So let's start with a presentation here for Bruce, you to follow. Yes, please.
Just to give a quick note for the audience, we have a chat available for you to submit your questions, and we will address them at the end of the session. Bruce, you can continue. Go ahead. Thank you.
Okay. Yes, feel free to ask questions, and we'll try to answer all the questions. Let me share with you our presentation. Just a minute, please. Is everyone seeing the slide? Okay. Let's start with...
I'm not.
Nope.
Still seeing.
Oh, okay.
Okay.
Yes. Perfect. So that's that's our main topic today, the new regulation of virtual assets in Brazil. And we have here a brief regulatory timeline. So at 2022, we had a federal law, and it was a very brief federal law with a few articles, just giving some principles and standards, but not diving into details, not even clarifying which entity, which governmental entity would be the regulator. It came afterwards, as you can see in 2023, when we have a federal decree stating that it would be Central Bank of Brazil. It was not clear if Central Bank would attract this oversight activity. So now we have a clear decision about Central Bank as the crypto regulator in Brazil. And afterwards, we have a main regulatory framework issued by Central Bank of Brazil, and that's the main concern here, because now we know the new rules of the game, we can say like that, because we were from unregulated market to now a regulated market. But to be clear, it's not a heavy regulation. On the contrary, our central bank here in Brazil, not only on the crypto market, but in the payments market, exchange market, credit market, traditional banking market, our central bank, it's mainly concerned to give the minimal framework to companies thrive in the market in a just book of rules. So to avoid asymmetries, to not impose too much burdens to companies, Central Bank of Brazil wants the innovation, wants competition. So it's one of the main concerns here in Brazil, and Central Bank is acting like that, not to create obstacles. So that's not the object of the new regulation. But one of the main consequences of this new regulation is the need of a license for those who want to be a virtual asset service provider. That's the name which our regulation uses to crypto companies. So to virtual asset service providers operate in Brazil. So here's a quick explanation of those rules that I just explained it to you. We have the law number 14,478/2002 with the standards. Then we have the decree stating that central bank would be the regulator. And now we have the main central bank initiatives, resolutions, and normative instruction, and that's going to be the key points of crypto companies in Brazil. So to start, who needs a license, and while I submit a license to operate in Brazil, can I continue to operate if I already was a company operating, or not? Do I need to wait for the license to start my operation? Well, we have both scenarios in parallel. If you were already operating, you have a timeline to submit your license, and while you wait for the license procedure to be finalized, you can keep going, keep operating. You don't have to shut down your operations while the central bank analyze your license request. So that's one scenario for those companies who are already operating. Okay, and for new companies that decided to start its operations after February 2 of 2026, you have to submit a license request, and you're going to have to wait until this procedure ends to start your operation. So we have both scenarios depending on the moment you started your operation. So that's very important for companies who were already operating, so you don't have to be scared of the in a scenario that you need to stop your operation because now I need a license. So that's not how it's going to work. Okay. And the regulatory framework is divided on those resolutions and normative instruction into topics. So resolution number 519 regulates the authorization procedures for virtual asset service providers and other institutions that decide to provide virtual asset services. Okay. Then we have the 520, which will regulate the incorporation and operation of those companies. And the next one, the 521, will regulate virtual asset service providers operations in the Brazilian foreign exchange market. Okay, that's very important also. And the normative instruction will establish procedures for reporting to Central Bank of Brazil information related to the provision of virtual asset service in the foreign exchange market. So if you want to understand how the authorization procedure will work, you must look at the 519 resolution. If you want to understand the incorporation of the company, how do I need to establish and create an entity, a Brazilian entity, we are going to come to that point with the corporate team, and Clara will clarify that point. But just to give an example, if you want to learn about incorporation of companies here in Brazil in crypto market, you need to look at resolution 520. So we have all those topics divided into different resolutions, and those resolutions will dive into the details of those topics. Okay. Beyond that, we have normative instruction 701 will establish the communication framework and minimum requirements for the technical certification issued by an independent qualified firm to accompany the notice of intent to provide virtual asset service in Brazil. Okay, and the normative instruction 704 sets forth procedures, documentation, deadlines, and information required for authorization applications by virtual asset service providers. The last one, that the normative instruction 704, we were waiting for this normative because the resolution, it was a more broad normative that didn't give all the details of the procedure. So now we know exactly how the procedure will be, which information do you have to give, which documents we need to submit, and what the central bank wants to know about the company to properly analyze the license request. So that's a very recent normative instruction that now we already have. The Central Bank of Brazil already set forth its normative. So now we can, it's a very good timing to talk about procedures of authorization and documentation required on those procedures, because if we didn't have this normative instruction, it would be only here saying what we would think central bank would require. So now we don't have to talk about what we would think, but instead what central bank is already requesting for those companies, okay? So to help you understand, we have here a before and after scenario. So like I said, until February 2, we had an unregulated marketing operating in accordance with international best practices, but we didn't have a regulator enforcing any kind of rules, okay? All domestic and foreign companies were permitted to provide virtual asset services here in Brazil. Now, we have a new regulation. After February 2, it is set forth. Central Bank is already ready to receive license applications. Companies that not providing virtual asset service by this date may begin operations only after obtaining the formal authorization. Companies that were already providing those services may continue offering the same service until October 30. So that's the important deadline that we must give emphasis here, because if you were already operating and you want to submit a license here in Brazil, you can do it calmly and submit until October 30. You don't have to rush it. We have time, several months, to adjust and prepare this documentation. And as a lawyer with experience in procedure here in Central Bank of Brazil, I can say that it is important to not try to rush those submissions. It's very important to prepare with quality the package of informations and documentation. It gives you a more fast response from central bank, and it avoids submit afterwards. A central bank can knock on your door and ask for more information, more documentation. So it makes the procedure takes a longer time, and I would not advise to do that. So it is important to give focus on the pre-submission phase and prepare the package of informations and documentations with detail, with calm, and until October 30, submit the application, okay? And as I said, upon submission of the authorization application, companies may continue operating until the authorization process is concluded if you were already in operation, okay? So let's talk about the different categories of virtual asset service providers here in Brazil. We have 3 different categories in our regulatory framework. So if you want to be a virtual asset service provider in Brazil, you must study our regulation and understand which category you are. So we have the first one, the intermediaries. The intermediary will provide, like the name said, intermediation services for virtual assets on behalf of third parties, and they offer purchase, sale, exchange of virtual assets, order execution and routing, virtual asset portfolio management, staking services provided to clients, market making or liquidity provision, and intermediating foreign exchange transactions involving virtual assets. So that's the intermediary category. We have the custodians, and like the name said, provide custody and safekeeping of third-party virtual assets. So the first difference, intermediaries do not provide custody. So that's one obvious key point here, so you can understand which category you will fit in. So the custodians may offer safekeeping and control of private keys and control instruments, recording and reconciliation of virtual asset positions, execution of client transfer instructions, handling of events affecting the assets, administration of data relevant to ownership, and staking when authorized and subject to specific conditions, okay? And the last one is the more complete license, as we can say, because the exchange will be the category or virtual asset service provider that will be able to provide all the services here in Brazil. So it's the more complete and can provide the custodians and the intermediary services combined. And so we do, and also like the name said, exchanges will be able to offer trading or virtual assets with integrated custody, full interface with the end customer. So it's the more complex and complete licenses that you can submit here in Brazil. All right. So foreign companies operating in the Brazilian virtual asset market. It is regulated under Article 23 of the Resolution 520. And foreign companies operating in the Brazilian virtual asset market as of February 2nd must transfer their operations to a Brazilian incorporated entity by that deadline that I said before, October 30, 2026. Okay. The transfer may occur in one of two ways. So institutions already authorized by the Central Bank of Brazil. That's one way. So a virtual asset service provider already operating as of February 2nd, or a virtual asset service provider specifically incorporated to carry out the transition. Let's go to option one so we can understand those two options and how it works, okay? Option one, transfer to an already authorized institution in Brazil. So the transfer may be made to, like we say here in Brazil, a CTVM or a DTVM. So a securities broker dealer or a securities distributor. So there are two figures already regulated here in Brazil by the central bank as well. And so you can transfer to one of those entities. So already you can transfer to a commercial bank, an exchange bank, an investment bank, or a multiple service bank. So that's all our categories of financial institutions, traditionally financial institutions here in Brazil. The receiving institution must obtain a technical certification, and that technical certification must be issued by an independent qualified firm, okay, attesting the reliability of compliance systems, infrastructure, and risk management specific for crypto activities, not only the traditional activities that entity already was operating, okay? And CTVMs and DTVMs may only operate as a virtual asset intermediary. So that's an important limitation here by the regulation. So if you want to be an exchange and you are looking for a transfer to a DTVM, that's not going to work because the TVM cannot operate as an exchange. So that's an important detail from our regulation, okay? And we have option two, so we can transfer to a virtual asset service provider. Operations must be transferred to a virtual asset service provider already operating as of February 2nd, or to a virtual asset service provider incorporated specifically for the transition. In this scenario, the general authorization rules will be applicable to the virtual asset service providers. And so, as I said before, we have that deadline in October. So if you're going to transfer to a new virtual asset service provider that's going to be incorporated specifically for the transition, that's the system that I already explained to you, okay? So if we need to submit a license application in Brazil concerning virtual asset service provider, we have a two-phase procedure, okay? And that's new because for other licenses, we don't have that division into phases. We usually submit the license request and wait for a response from our central bank. That's a new kind of procedure that we have a phase one, probably because it's a new regulated market. We are going to have several license applications from a lot of companies that need to adjust to the new regulation framework. And I think that's the reason central bank decided to create those phases. Okay, so phase one would be the first submission of the authorization application, including the request and certain corporate declarations. So phase one is mainly declarations, informations that you will provide to the central bank, and probably on phase two, you will have to give documents and evidences that will corroborate those declarations. Okay, so phase one is a little bit simpler than phase two. It's going to be a first filter to central bank, and if you proceed to phase two, it's going to be a phase more focused on documents and going into details of the directors, partners, corporate structure, reputational aspects, and other specific details of the operation itself. Okay. I'm not going to read everything here. Phase one and phase two is very straightforward in our regulation. But as I said before, when you submit your application to phase one, it is important for it to be complete, for it to be clear, for this, because central banks going to receive a lot of requests, a lot of license applications, and the more clear, the more complete, the more organized your package of documentations and declarations, more faster the procedure will take. Okay, so it is strategic to dive into all the details, all the items that central bank demands, and pay attention to not forget or not give clarity at some points. It will be good for the license application to be faster. Okay, so you have a license as fast as you can. It is important to note that on phase one, you need to be compliant with minimum capital and net worth requirements. That's important to highlight, because we had a recent modification concerning all the oversight companies in Brazil. So central bank increased. It's more expensive today than a few months ago, because the minimum capital and the minimum net worth requirements are more demanding. The values increased. So, for example, for a payment institution, usually had a 2 million reais demand, and now it's much more than that. It's more than triple. So we, that lawyers that work with closely to central bank and understanding the regulatory movements in Brazil, we can say that this movement to increase capital and net worth requirements came in a scenario where central bank wants to not to avoid startups and small companies, but since Brazilian market is more mature, central bank decided that we cannot have companies operating in payments market, in crypto market, in credit market, that don't have the capability to invest in risk management and in prevention of money laundering and other important aspects of our regulation. So that's why we have an increase in minimum capital and net worth requirements. Okay, it is important to highlight as well the need to evidence technical capacity of officers compatible with their roles. So that's one of the main topics here at phase one. So they're going to look at the directors, the partners, the officers, and understand why they are experts in crypto market, where they worked before, what's your reputation on the markets that you used to work, and if you were operating in Brazil or not, and that kind of information. It's very important to be as clear as possible in this topic, okay? And then we go to phase two, and in phase two, we cannot say how much time it will last, okay? It usually takes at the maximum 1 year, but we cannot state if that's going to work with a bunch of crypto licenses. As we said, we are going to have several license procedures concerning crypto market. So let's see if our central bank will have the capability to address all the procedures at once in a fast manner. But we usually say that it won't take longer than 1 year. I think that's the key points here concerning those topics. I already said too much. If you have any questions regarding those topics, please feel free to interact with us. I'm going to let Ana Clara dive into the corporate framework of the crypto regulation.
Hi, everyone. So today we have separated for you. Eduardo, can you pass the slide, please? Thanks. So, hi everyone again. Today we have separated for you 4 key topics on the corporate framework under the central bank regulations applicable to the virtual asset service providers. Okay, so before I start my presentation, I would like to make some disclaimers. First of all, to clarify, whenever I mention BCB, I'm referring to the Brazilian Central Bank, which is a term that we use here in Brazil. And second of all, it is important for me to point out that we will address these matters in general terms. So any specific recommendation will require a careful assessment of the client's current structure and the intended operating model. And as Eduardo said, BCB regulations set out detailed corporate requirements for the virtual asset service providers. But for this presentation, we have selected the topics that we consider the most relevant ones. So with that in mind, today we will cover the corporate forms that are required for their virtual asset service providers, who may act as their shareholders, the virtual asset service providers management structure, and the capital and net equity applicable requirements. So following. BCB requires that all virtual asset service providers be incorporated in Brazil, either as a limited liability company or a corporation. And you can, Eduardo, you can follow this slide. So to define the most suitable corporate form, either the limited liability company or a corporation, it is important to understand the current corporate structure of the client and the intended structure for the company that will work as a virtual asset service provider. So if the company will have more than one shareholder, a corporation will likely be preferable, as it is easier in this case to address divergent interests among the shareholders. On the other hand, if the company is expected to have a single shareholder, a limited liability company may be a better fit. And actually, if you intend to have a sole foreign shareholder, a limited liability company will be required, as the Brazilian law does not allow a corporation to have a single foreign shareholder, okay? And in any case, as I said before, we should review the client's structure, the current structure, and assess the tax implications of the corporate form before recommending any option between the Brazilian limited liability company or the corporation. And you can pass this slide, Eduardo. Thank you. And also, BCB provides that only certain people or entities may be the direct controller of a virtual asset service provider. So here we're talking about the first layer of shareholders of this type of company. In summary, direct control of a virtual asset service provider may only be exercised by individuals, but it cannot be incorporated with a sole individual shareholder. Institutions licensed by the BCB, such as Brazilian corporate banks, as Eduardo was explaining, foreign financial institutions or similar entities that are established abroad, such as foreign banks, or Brazilian entities that has the exclusive corporate purpose to hold equity interests in institutions that are authorized by BCB. So these are the entities and people that can have the direct control of a virtual asset service provider. And in addition to that, there are specific eligibility requirements that are applicable to all the controlling shareholders of a virtual asset service provider. Okay, so in the licensing process, BCB will typically assess, among other matters that are in the regulation, the financial capacity of the controlling shareholders, as Eduardo told, and they have to be consistent with the capital required to structure and operate a company, and also considering the market contingencies that are common in virtual assets market. So one of the first requirements that BCB will analyze is the financial capacity of the controlling shareholders. And for the virtual asset service providers that are already operating here in Brazil, BCB will also take into consideration the proper company net equity and also their profits over the last 5 years. So this is something very important. If you already have operation here in Brazil, BCB will take into consideration in the licensing process the profit and the net equity over the last 5 years. Another point that BCB will take into consideration is the reputation of the controlling shareholders that are individuals. So they will analyze the existence of criminal investigation, relevant judicial or administrative proceedings related to insolvency, liquidation, and bankruptcy, and other similar circumstances. And another point that is very important here in this regulation is that BCB can also require the controlling shareholders to enter into a shareholders agreement. And in this agreement, they will expressly define how the control will be exercised by the shareholders. So maybe BCB will ask the VASP to establish a shareholder agreement with clear rules regarding the exercise of control of this entity. Okay, and finally, the last topic in this slide is that investment funds are not allowed to act as controllers or members of the chain of control of a virtual asset service provider. So investment funds can be the controller of a virtual asset service provider here in Brazil. Okay. Eduardo, can you pass the slide? So the last one. Yeah. So all transfer of control or changing the control chain will be submitted to prior authorization from BCB. So the authority can assess whether the incoming controlling shareholder meet all the applicable regulatory requirements that we mentioned. Okay. And now talking about the management structure, you can pass, Eduardo. It's important to take a step back here and to clarify the traditional corporate governance here in Brazil. So it's usually divided in board of directors and the officers. This structure is very common when we are talking about corporations, Brazilian corporations. But this structure can be also a reality in the limited liability companies. So the board of directors is responsible for setting the company's general guidelines and for supervising and guiding the officers. On the other hand, the officers are responsible for the day-to-day management and for conducting the company's business. And the BCB regulation is directed to the officers, okay? So it establishes that the virtual asset service providers may appoint at least 3 officers, which will be accountable before BCB for some functions, okay? So they have to be that there has to be an officer that is responsible for the conduction of business, which is the officer that is responsible for the regulated activities of the company, such as the intermediation or custody, as Eduardo was saying, the prevention of money laundering, terrorist financing, and proliferation financing, internal controls and overall regulatory compliance, cybersecurity, and also the risk management. So in practice, it's very common to appoint one officer that is responsible for the conduct of business, a second officer that is responsible for the prevention of money laundering, internal controls, and cybersecurity, and usually this is the compliance officer, and a third officer is responsible for the risk management. So this is the common structure here in Brazil. And in general, as I said, it's very common to accumulate the roles. So the compliance officer is responsible for a lot of these functions. But there is one point that if there is an incompatibility or a conflict of interest, or if the regulation establishes a segregation, then you cannot have the accumulation of roles, okay? So, for example, the compliance officer and the conduct of business officer should be different people, because the compliance must overview and supervise the business officer, and therefore we can avoid any self-review, okay? And as the controlling shareholders, Eduardo, you can pass the slide, please. And as the controlling shareholders, BCB establishes as well specific requirements for the officers of a virtual asset service provider, okay? So all of the officers of these companies must be resident in Brazil. They don't have to be Brazilian, but they have to have a Brazilian residency. They have to have an unblemished reputation. So in this case, BCB will analyze as well the proceedings regarding the officers that are appointed. They must have technical qualifications and professional experience that are compatible with their function in the virtual asset service provider. They must not be subject to any statutory disqualifications, and they must not have any relevant criminal convictions. They must not have been previously subject to regulatory bans, suspensions, or similar convictions. They must not be involved in or have any history with bankruptcy or insolvency proceedings as applicable. And they must not have had a prior authorization request denied by BCB due to false, incomplete, or misleading information that are provided in the filings, okay? So these are the requirements for an officer in these companies. And Eduardo, you can follow. And is another point that is very important, that whenever there is a new election of a new officer, the election will be subject as well to BCB's prior approval. So BCB can assess whether or not the new officer meets all the requirements in the regulation, okay? And at last, the last topic that we have selected here Eduardo, you can follow. Thank you. Is that the virtual asset service providers, they must meet and they must maintain a minimum paid-in capital and a minimum net equity. Okay, so the values, the amount that they have to have, will depend on the services that the company may provide. So in this table, we have indicated the amount needed regarding each category of this type of company. And if the company provides other regulated services, these values may change accordingly, okay? They may go up. And also, the capital of the virtual asset service provider, they must be paid in Brazilian reais, and all capital subscriptions must be fully paid upon subscription. So it's not possible to have a deferred payment of this capital, okay? And regarding the capital increases, this type of operation can be paid with retained earnings of the company, profit reserves, or shareholder credits against the company as well. And in these cases only, it will not be necessary to obtain the BCV's prior approval. When we have another change of the share capital of these companies, BCV will also have to approve before the operation. Okay, and so everyone, these were the corporate topics that we have separated for you, and Pedro will take from here to walk you guys through the tax matters.
Thank you, Ana. Eduardo, if you can pass the slide.
Yes, let me share the text slides just a minute. Just a second.
It's kind of a coffee break.
While we prepare the tech presentation, if you have any questions, please feel free to share here with us at the chat. And we will try to answer at the end of the text presentation. I think Gustavo already gave us 3 questions here.
Are you guys seeing?
Yes.
Yeah.
Okay, but I just, okay, so
Yeah, I think it will same file.
Let me see. Yeah, it is. I'm sorry.
Let me show you.
While we solve this brief technical problem, let me dive into the questions made by Gustavo. He asked here, how should global companies address potential conflicts between Brazil's PSAV or VASP, as we say, regulation, and foreign frameworks such as MiCA in the European Union or US state level crypto regimes? So that's a very interesting question because we don't have globally a crypto standard regulation for all the countries. I don't think we have in any other market, and crypto is not different. Uh, we can say that Brazilian regulation it's not inspired by MiCA, but there are several points in common. Uh, when we talk about the data protection law from Brazil, we can say that our data protection law is ultra inspired in GDPR, but that's not the case here in crypto regulation. But there are several points in common. But at the end of the day, the Brazilian entity will be required to comply with our Brazilian regulation. And if our Brazilian regulation somehow is different from other jurisdictions, the company will have to adjust its operational aspects to comply with Brazilian regulation in a different way. For example, as it complies with Singapore regulation. Let's give an example. But here in Brazil, you have to adjust your operation to comply in a Brazilian fashion if it differs from another jurisdiction regulation. Okay, so at at this point, it's important to dive in the details of our Brazilian regulation and understand if it's very different from other jurisdictions that the company operates. So the company can organize itself in a way to comply with Brazilian regulations. So you cannot avoid complying with any Brazilian aspects that differs from other jurisdictions. Okay.
Okay, Bruce, thank you for your reply. We have another one here that we received for our audience.
Okay.
Okay. The first, the next one is in a multinational corporate structure, does regulatory responsibility rest exclusively with the Brazilian subsidiary authorized as a PSAV, or may liability extend to the foreigner parent company? What do you think
I
about
think
that?
I think Ana Clara can dive into this question, but I would say that the responsibility rests exclusively in the Brazilian subsidiary entity, right?
Yes, yes, that's it.
Because we have a corporate system here in Brazil where liability is limited at
Mhm.
the Brazilian entity. So the Brazilian entity would be the one that holds the license, the one that operates, the one that will eventually have to respond to a judicial procedure. In Brazil is very common. That's another topic that we can talk here about for hours as well. But it's very common here in Brazil. If the company have success in a B2C system, it's almost impossible that you will not have a few judicial procedures against you. So it's common here in Brazil because of our judicial system, but at the end of the day, answering the question, the responsibility will rest exclusively with the Brazilian subsidiary entity.
Okay.
Okay.
We can give the last one for the end of this presentation.
Okay.
Go ahead, guys.
So my turn now. Who's sharing the screen? Is it Anna?
It's me.
Or
Yeah, it's me. Okay.
Okay, thank you, Anna. So I'm sorry you all for the interruption. I'm going to share now with you what happens in Brazilian tax landscape that may directly affect crypto businesses operating here. So let me start by explaining what crypto service providers and the main cost structure for entering Brazilian markets. So first, we need to understand that the VASPs gross revenue will come from mainly four incomes. One, your brokerage fees. Second, commissions, also spreads on the operations, and fees charged upon services rendered like deposits, withdrawals, custody fees, and revenue from other additional services. So something important here to highlight is that crypto that's sitting on the customer's wallet will not directly affect the company's revenue for tax purposes. So the companies are not taxed for trading, for exchanging the customer's assets. They are taxed only for the fees they receive when handling them. So regarding the Brazilian tax system structure, taxes on profit, only federal taxes apply on companies' profit. We're looking at a 34% tax rate applied on the company's profit. 34% is already the effective tax rate that combine some specific federal taxes, and this is the standard taxation here in Brazil for companies' profit. If you are a company with low revenue, a revenue that doesn't go up to $15 million approximately for each year, you can be taxed under the presumptive profit regime, which is an alternative created by the Brazilian legislature to simplify the tax accrual. So in this case, you just assume that the company has a 32% profit margin, and you apply the 32% upon the gross revenue, and then the 34% combined tax rate. It aims to simplify the tax obligations. So this is pretty much how you tax profits in Brazil, 34% on the actual profit, or considering the 32% assumed profit margin. Then you have the taxes on not on profits, but directly on revenues. So you have federal taxes on revenues, which are PIS and COFINS. They have a combined tax rate of 9.25% in the standard regime. So if you pay your profits tax under the standard regime, you just calculate your actual profit and then apply the 34%. You are going to pay 9.25% of PIS/COFINS, the federal taxes on revenue, and you will be able to offset credits from previous operations. So this is a non-cumulative regime. If you are paying your profits under the presumptive profits regime, the tax rate for PIS/COFINS will be lower, but you won't be able to offset credits from previous operations. So it's going to be a cumulative regime, and the combined tax rates will be of 365%. And we also have taxes on revenue, municipal taxes on revenue, the so-called ISS, which is the tax on services, and the tax rate may go from 2 to 5%. It's going to depend where you are. Each city has the autonomy to set its own tax rate. So I think you can pass this slide down. Well, now this is what I just told you. It's what happens today, but Brazil is going through a tax reform, especially on revenue taxes. So the federal taxes, PIS/COFINS, and the municipal taxes, tax on services, ESS, will give place to a combined VAT tax of we estimate 28%. So this is not yet defined. We are still developing our legislation. We are already under the transaction period, which is going to last for more than 5 years ahead. Next year, we're going to have the first step of the transition. And what's important here is what happens in any system, any tax system that adopts VAT tax. Are you going to tax crypto operations, crypto trading, crypto exchanges, or not? Most of the systems do not consider crypto exchange as operations that may give rise to VAT tax, but this is not clear yet in Brazil. So this is an open question, and it's going to be really important because it can make the tax burden significant. Well, it can maybe even prevent the operations here in Brazil. I don't think this is going to happen, but this is something we have to pay attention. This is not enforcing yet, so this is something under development. Now, Anna, if you can. Okay, so this is a problem that we are facing right now. Brazil has IOF, which is a tax that levies upon financial operations. And for many years, crypto transactions with regular money exchanges were not considered foreign exchange operations for IOF purposes. So they were not taxed as such. So if you sell Brazilian reais to buy United States dollars, you will have to pay IOF, the tax on financial operations. But if you change Brazilian reais for any stable coin, you wouldn't have to pay. Recently, you still do not have to pay. You need the tax framework to be updated to allow this taxation. But recently, the central bank issued a new regulation. Eduardo already went through it. And one of the things they said in this regulation is that crypto exchanges that operate stable coins might be considered the same as regular money exchange. So we do think that this is the first step to allow the tax regulators to apply the IOF, the tax on financial operations, on stablecoin exchanges. But we still do not have anything right now. We do think the regulatory landscape is changing, but nothing concrete up to this moment. But this is something to pay attention as well. And on the next one, please. So to wrap it up, beyond taxes, there's also compliance. Here in Brazil, we are world champions in tax compliance, and this is crucial. The regulatory requirement is called Decrypto. It's the name of the declaration you have to send to the IRS. So any company providing services related to crypto transactions in Brazil, whether you are an exchange, intermediary, or the platform, you must file a monthly declaration. This is mandatory. And you need to report purchases, sales, swaps, transfers between wallets, everything that moves, everything that your client does. You have to report it monthly and then consolidate once a year. If you don't do that, there's going to be fines that may go from $300, which almost not really material, but up to 3% of the transaction value. So it may add up to a significant amount, depending on what's wrong with the declaration. So this is mainly it for the regulatory crypto framework regarding tax compliance. You would also have to file all the other declarations that regular company already have to do it. So I think this is mostly it for the tax part. Maybe it may look a bit complicated. It does require compliance investment, but Brazilian authorities do know that Brazil is a huge market, not yet fully explored, and as Eduardo said, I don't think Brazilian legislators have overregulated crypto, at least for now. So if you are considering entering the Brazilian market, this is the time to understand these rules, build your compliance engine, and make all the informed decisions so you don't have any problems operating here. The opportunity is real. Thank you. I don't know if Eduardo wants to add anything, but it's a pleasure to be here with you.
I think we cover all the main points regarding regulation, tax, corporate. Maybe we can dive in on questions still pending. I think we have still one question unanswered.
Can I say some words?
Sure, Siran, go ahead.
Just adding to my colleagues' brilliant presentations here, my camera just turned purple here, so I closed it. I don't know what happened.
I think we all prefer. Yes, yeah. I think we all prefer not to see you on purple. So go ahead.
Of course. Just a few operational observations. We talked about the requirements of the authorization process itself, but even the authorization request indicates that VASPs entity should increase its compliance levels in some areas, hire some staff in Brazil. I will talk about these areas here. We will have the authorization process itself. We have to adequate corporate structure, capital, net equity, minimum governance framework, designation of responsible officers and statutory administrators, implementation of internal policies. We can talk about to anti-money laundering and counter-terrorist financing. We will have to compliance with our legislation here in Brazil. We will take place in risk-based know your customer procedures, QIC, ongoing transactions monitoring, reporting of suspicious transactions. We can talk about governance and internal controls too, integrated risks and regulatory compliance structure. It's very important that in the operational phase we have this governance. So disclosure information regime, cybersecurity requirements as policies, as consumers protection, safeguards, and market integrity. We will have to obey all these operational requirements that we have to present to the central bank in the business plan. That is the most important documents we have in our authorization process. So that's it. I just want to say a few words. Thank you guys for the attention. I think we could pass to the questions, as Bruce I say.
Just to complement what Cyrano said, and it was very interesting to point out that important detail, because we only talked about the specific crypto regulation and how you must adapt to that new regime to submit your license and what are the corporate requirements. But as soon as you become a crypto regulated company here in Brazil, you have to comply with several other central bank regulations as a Brazilian entity supervised by central bank. It would be, I would say to Gustavo, we can schedule a new meeting only to talk about those points, because as you see, Cyrano detailed a lot of regulations that concern to crypto, but also non-crypto companies supervised by central bank. And as a Brazilian crypto, you have to look at it as well, and it must be at least in a minimum preliminary stage when you prepare the business plan. And the business plan is one of the most important documents from that package that I said before that you must submit to central bank.
I like this idea, Bruce, to schedule a new one webinar with this topic. I believe that will be so good. We have two more questions here. The first one is it legally acceptable for custody of Brazilian clients' crypto assets to be performed by a foreign group entity, or will the regulator require direct local control and supervisory access over the custody infrastructure?
Yes.
This is interesting question.
Yeah, exactly. That's exactly what I was saying. Because you don't have to have a self-custody. That the regulation do not require for you to have a self-custody. You may use third parties to be your partner to provide a custody service, okay? But, and that's a very important but, you do not you are not gonna be free from responsibility if you do that. If you use a third party custody provider, you are still responsible on behalf of the central bank, because you are the company that holds the license. You are the crypto company. You just made a business decision to use a third party custody provider, but you are responsible for that choice. So if you have any kind of problems with that service
Eduardo,
provider, yes.
in any case, you have to establish a company in Brazil, right?
Yes, the crypto company must be a Brazilian entity. Yes.
And the company that's going to provide the custody services must have their licenses as well here in Brazil.
Yeah, if it's only an infrastructure, a technology service, no. But if it provides more than that, it is also a virtual asset service provider, yes. So that's it. You can use, and we can dive into details. Of course, each operational require us to understand the case. I think it depends. We have to know which company we're talking about, how they operate, what kind of adjustment they want to make in their business model to use a third-party service provider. But in general, you are going to be still responsible for your choices regarding third-party service providers, and you still be responsible to answer to central bank if any problems arise.
Okay.
So if you want to quickly establish your operations here, you would basically have to create a Brazilian entity, and then you can hire the infrastructure from third-party companies that already operate here.
Yes.
Okay.
If I can
Thank you.
add on that, is that I'm sorry, Gustavo, can I?
No problem.
Please, huh?
Okay, so the BCB regulation establishes certain rules regarding the hiring of relevant services, and custody is one of them. And the entity, the virtual asset service provider, may comply with a lot of rules regarding the choice of the person that you're hiring, and you have to fiscalize their activities as well. So it's very important to know that we have specific rules on hiring relevant services, and this is a term that is defined in the regulation as well. So it's important to have that in mind as well.
Nice.
Great clarification.
Yeah. And the last one is two questions in one. It's about what are the key deadlines that these companies need to pay attention, and do crypto as a services company need their own PSAV license?
Okay, first of all, about the deadlines, we have two important dates here. February 2, so that's the date that you should be operating. So if you were not operating until that date, you will be in a new regime where you need to first submit the license application, receive the license from the central bank, so you can start operate. If you were already operating before that, you can still continue to operate while your license procedure go on. Okay, so that's the first important date and their consequences. The second one, October 30. So if you want to be a virtual asset service provider in Brazil, regardless, you have, and you were already operating, and you wanted to keep operating, you must submit your license application until October 30. If you were not operating, you can submit whenever you decide to be a virtual asset service provider, but you have to wait for the license to begin operate. Okay. And the second one about crypto as a service, can you repeat, please?
if the crypto as a service companies need to apply the PSAV license too.
That's a very good question because crypto regulation in Brazil is very recent, and our banking as a service regulation is very recent as well. It's like our two main topics here in Brazil. The central bank is the regulator from both teams, and it's not clear, as for me it's not clear. I think that's a very interesting topic to understand and to see how it's going to go. But if I have to answer today, I would say that central bank is not willing to give incentives to crypto as a service right now. I think now he wants to crypto itself to be established first. So the crypto companies that want to operate in Brazil submit their licenses. They are going to be crypto companies licensed on behalf of the central bank. And afterwards, we have to wait to see if the banking as a service regulation will be adjusted to the crypto reality, okay? Because it's not in the regulation that we have today, it's not clear if it's feasible for the central bank for you to have crypto as a service as regulated today regarding the banking as a service regulation, because we have a list of activities on the banking as a service regulation, and the virtual asset services is not there, at least not right now.
Okay. And Bruce, you said that companies that not operated until February 2 not be able to enjoy the transition period. What is the proof of the operation with this time? It's there is something special that the company did to declare something like that.
It will depend. Let's give an example. If you are a custodian, if you are an intermediary, if you wanted to be an exchange. So first of all, you have to look at your category. Which category do you want to be? So, or do you want to be, or do you feel that you are right now when you try to look at the regulation, look at yourself? Well, I think I am in the Brazilian regulation a custodian, or I think I am an exchange. Okay, so when you do that exercise, then you're going to, one of the slide that I put there was the all the activities that each one of the categories they operate. So you will have to give some evidence, some proof that you have clients, operations regarding those activities. There's not a quantity demand. So if you have one client, if you have millions of clients, you are still operating at the same way, because you may be a big global company already established with millions of clients, or you just began, but you are lucky enough to have one or two operations before February 2, you are going to still be considered a virtual asset service provider who are already in operation.
Okay. Thank you for clarifying this question. And guys, we are in the final of our webinar. I would like to say thank you for BBL team for this amazing webinar and the big content. And I believe that our audience like a lot this experience. Thank you, Ana Clara, Bruce, Pedro, and Cirano. And if you in our audience would like to talk with BBL, let us know that we can connect you with this amazing team. Okay. Thank you for this webinar, guys, and see you later. Bye bye.
Thank you,
Thank you,
everyone.
guys.
Thank you,
Bye
guys.
bye.
Bye.
Thank you, SFI. Thank you, everyone.